Okay, this is Carolyn Rice, School Board Chair. The school board is resuming its workshop format, and we are here to welcome School Board Counsel Mrs. Cami Linetti and Dr. Spence for a presentation on the new collective bargaining laws.
Good evening, Madam Chair and Vice Chair, school board members, Dr. Spence. I'm Cami Linetti. As school board legal counsel, working with the superintendent and certain members of his staff, we are going to present to you tonight just a general overview on the collective bargaining laws that will go into effect on May 1st. I want to make it clear to you right now, you have on your agenda, we will be going to closed session afterwards for direct guidance and some legal advice concerning collective bargaining issues and some other matters. So please understand that what we're presenting to you now is an overview of the law. We can discuss some of the issues on it, but for specific legal advice and direction, please save that for closed session. We're not going into that right now. Again, if we can move to the next slide, Sonia. Would I have the one? Maybe I'm doing. Oh, well, there I go. Okay. First up, we're going to cover tonight. One is a review of the legislative changes that are effective on May 1st, 2021. Second, we will be covering the outline of school board options under the new law. Third will be the outline of 2 collective bargaining models. And fourth will be the recommendations for consideration for FY22. First up on the legislative changes. During the FY20 General Assembly term, which was actually last year's term, not this year, the General Assembly passed Senate Bill 939 and House Bill 582, which allowed local governments, which includes school boards, to enter into collective bargaining agreements with their employees. Governor Northam extended the effective date from July 1, 2020, as initially proposed, to May 1st of 2021 due to the pandemic and the various demands on government at that time. This would then allow the local governments more time to prepare for the collective bargaining decisions that would need to be made. For those of you who have participated in some of the VSBA's training on this, it explains the background and the history. There's a task force report that goes into the long history of where we are in Virginia on collective bargaining. I don't intend to go into that tonight. Virginia remains a right-to-work state, and the new legislation does not require that local governments participate in collective bargaining. Instead, local governments in Virginia now are able to consider and enter into collective bargaining agreements with their employees. However, Virginia currently does not have established procedures or models for public employee collective bargaining. That means that any local government or school board intending to implement collective bargaining will need to create and implement rules, procedures, policies, and regulations to define how collective bargaining will work in its locality or if collective bargaining will not be allowed. On May 1st, 2021, whether a local government or school board is taking action on the issue of collective bargaining or not, groups seeking certification as bargaining units can submit requests to local governments, and such requests then trigger a 120-day period in which the school board has to respond. That is why we're coming to you tonight on some of these recommendations. What you see on your screen is the current summary of the law at 40.1, 57.2. Again, noting for you that the school boards can take action on behalf of school board employees. You are not required to adopt anything, but if you don't adopt anything, you are still subject to what the law is. We're going to discuss your options at this point. Option A is to take no action. Again, option B. Option B actually has multiple options. Option B is to pass a resolution, and there are multiple options that can be considered under option B. One option would be for the school board to vote to not allow collective bargaining. Another option would be the school board to vote to allow collective bargaining. This option would require the development of the necessary policies, regulations, procedures, the budget, the staffing, and the necessary training. Yet another option would be if the school board could vote to allow collective bargaining, but use a different format than binding arbitration. The employee input process is an example, as is the meet and confer. There are other alternative processes that have been used by other locations and in some versions in the school division in the past. Yet another option is the school board could defer the decision on collective bargaining and not accept any requests related to collective bargaining until such time as the school boards have the time to study the matter and make informed decisions. Again, under option A, if you take no action, the board is not required to proactively take action under the new law. However, as of May 1st, groups seeking what they call certification as a bargaining unit can then submit a request or a petition into the school board. That will then trigger a 120-day period in which you then have to make decisions. If you have not made a decision by then, you will still have to make a determination as whether you're going to accept it. And again, you have no control over the process, the way it comes in, and what the requirements are if you take no action. You will then have to make a decision based on the information coming in, or you will have to move quickly to make your own processes. Again, on option A, it provides no definition. The code provides no definition for certification is. We know from national labor procedures what happens in these areas, and private labor procedures what a certification means. Again, there is no current guidance in Virginia. There are some localities that look at it. I believe the city of Alexandria has recently adopted procedures that we could look at. Otherwise, we would be looking at other states. But again, there is no requirement in Virginia that defines what certification is, in which case you would then have to make a decision as to what certification is. You would also have to determine how a certifying letter would come in, is the petition, what it would look like, how many people would have to participate in that, what you would accept as evidence that. Those are all decisions that you would have to make. And again, Virginia does not currently lay out any procedures for you. These are decisions you as a school board would have to make. Oops. Yeah, and the earliest, there we go. The earliest an association can submit a request for certification is May 1st. Again, that is set by law. If a valid certification is received on May 1st, 2021, that would give this board until August 29th, 2021 to make a decision. As mentioned, some of the things we're going to discuss with you, all of these procedures would have to be in place. You'd have to make determinations on that. We would have to adopt necessary policies. We would have to adopt the necessary regulations. That would have to clear the policy review committee in time. It would all have to be in place for you to make a decision before August 2021. And again, I ask the school board to give careful consideration to what other matters the school board needs to address before the start of the new school year, because this will take priority into the decisions you have to make in there, and we would have to schedule for it. And again, remember, before it gets to the school board, it would need to clear the policy review committee. We would have to clear the necessary departments. The school board does not currently have established procedures for recognizing any employee groups. Some employee groups have established relationships with the school division. School administration has reviewed its records and can present the information on this slide as examples of currently existing employee groups. John Muir, your Chief Human Resource Officer, can answer questions as to how this information is collected. Mr. Muir, Sylvia.
Are there questions? Well, let me explain. The first one, we have payroll deduction. We put a little asterisk there, which I don't know if y'all could read it. I'm not able to read it from here, but I know what it says. It says the VBA information was pulled from payroll deduction. Thanks. And the bottom two were pulled from payroll deduction. So it also indicates that there may be some people membership not represented there if they pay directly. The other ones were received from the presidents of the associations, of those other associations.
Again, at this time, these do not stand as recommendations concerning groups. This is just an example to you. The best you have right now in the Virginia Beach School District are these types of examples. They will not necessarily meet the requirements or that would have to be put into place for collective bargaining units or certifying a bargaining unit. But just an example, if you take a look at the numbers, there are a lot of associations in there that do not necessarily represent a majority of school employees. Again, decisions you are going to have to make as a school board as to what you will accept as a bargaining unit. Moving on to option B, if you pass a resolution, again, a resolution would establish and define what are your bargaining units, would identify the matters that would be subject to or exempt from bargaining. Again, some of those issues you will have to determine in a resolution, which will eventually become a policy or a regulation, would be questions such as, what will the school board define as a bargaining unit? How many employees must belong to that bargaining unit before the school board will consider a petition for certification? What groups of employees will not be allowed to certify as bargaining units? How and when will the school board accept certification petitions? Will the school board hire outside negotiators, or will the student superintendent have to designate staff to handle these procedures? In a subject that we have not yet mentioned, what topics will the school board agree to negotiate? Is the school board fully informed regarding what subjects are generally open to negotiation and which matters are generally reserved for the school board exclusively? Is the school board informed about what rights and procedures already exist in law and regulation, as well as school board policy and regulations? What form of collective bargaining would the school board allow? There are alternatives such as meet and confer, which may be considered and chosen over traditional collective bargaining procedures. Is the school board informed about the benefits and drawbacks of each one of these procedures? Again, continuing on with option B, the board has an almost blank slate because at this time in Virginia, there are no good examples or policies or procedures to follow. So if you're going to look at a blank slate, what would you include in this resolution? And therefore, what would your collectively bargain look like in Virginia Beach City Public Schools? It does not necessarily have to look like any other jurisdiction, and it does not necessarily have to look at what the national procedures are. The only guidance in the law is that the locality's procedures for the certification and decertification of exclusive bargaining representatives must include reasonable public notice and an opportunity for labor organizations to intervene in the process for designating an exclusive representative for a bargaining unit. And there are different collective bargaining models that can be examined and looked at. And again, we strongly will be recommending the school board explore some of these issues. There's a meet and confer process. This is more commonly understood in Virginia. It's been used in the past. Meet and confer provides a process and forum for labor representatives to regularly meet with senior leadership and management within their departments. The purpose of the meetings are to discuss and resolve workplace concerns, provide feedback on an array of topics related to their employment, and can take several forms, both formal and informal. It can include a governing board policy and a regular reports to the board. It can include labor recommendations on various workplace issues. It may include a formal labor management committee and or guaranteed seats for labor representatives on staff committees. It typically does not result in a formal collective bargaining agreement and may result in a memorandum of understanding. If you've been on the school board for a long time, particularly prior to January of 1999 when we stopped this process, there were memorandums of understandings that we entered into with various groups. That would probably close to what we would consider the meet and confer process. Another form would be the traditional collective bargaining management. In this case, management and labor representatives meet to negotiate a formal, legally binding collective bargaining agreement, usually referred to as the CBA. This is a legal document that you would sign and you would be held accountable for. CBAs govern the terms and conditions of employment for the bargaining unit employees, and they can override general board policies and procedures. Labor management typically negotiates over issues such as pay, benefits, hours, leave, work, health issues, and anything else you decide is appropriate. Typically, they have formal procedures for governing disputes between labor and management. These are not necessarily the grievance procedures for employees. It's if you cannot work through the processes that you've set in place. It is a different form of grievance procedures that you would be handling. It also involves a number of management labor issues are resolved through the neutral third party, such as quasi-judicial agencies. Many states that have public employees, that have a public employee relations committee, a PERC type of commissions, what they're normally called. You then would go to this group. That has not been established in Virginia. I expect that you will begin to see that in the next couple of years, which means we will have to redo these processes if you enter into collective bargaining. But normally what would happen in these cases, you then end up hiring people that are certified as arbitrators. That becomes very expensive. In most cases, you will hire an attorney firm or specialized firms, in which case the labor unions would have them, or the bargaining unit that you certify. In addition, you would most likely be hiring your own agents, not necessarily somebody in the school division. That will add an additional cost to you in contracting for those particular groups. Once you do that, if Virginia then establishes more formal boards, there will be a procedure that can be costly and expensive that we will also have to follow. Again, I take you back to what your options are at this point. Option A is take no action. And reminder, take no action doesn't mean that nothing happens. It just means you wait till somebody comes in and asks you to do something, and then you will have to begin the process. Option B, it's a resolution process, and there are a number of choices. Again, the choices are you just say we do not want to do collective bargaining, pass a resolution. You will allow collective bargaining, or you allow collective bargaining with some type of alternative process in place, or you can defer the decision, and there are subcategories to each one of those. Again, looking at the considerations, we just mentioned those. There are many options we can look at. Our concern, after discussing with the superintendent and his staff, is knowing that the date when you can receive the first request to consider a collective bargaining unit, you have many, many decisions that you need to make. We know that many of you have participated in VSBA trainings and have done some research on your own. We still feel that as a board, you need to come together and you need to provide some direction to us so we can help you figure out where you're going. And again, as I mentioned, there are multiple options to do. We have many things to consider. There would be many policies to consider that we have to go through. And there are things that we have not yet discussed with you about the finer points on definitions, on procedures, on budgets, on staffing that would need to be made. All of those will require some work on the entire board's part to make some further decisions. So based on what the superintendent, staff, and I have talked with together and what we've researched on past practices, the current recommendation we're going to have for you is that the board enter into a closed session to discuss the legal matters with counsel on collective bargaining decisions so that you will then give us direction as to where you'd like to go with this so we can come back with more formal recommendations for you to handle that. We do not believe at this time you can put off making any further decisions. I think you need to give us direction so we can help you do that because we believe on May 1st or sometime in the week after, you will start seeing some of the requests to start showing up, and we would like to have the time to work with you and make a better decision. Again, we will be going to closed session to discuss specifics on it, but as far as information generally about how the process works, what we've done in the past, we can answer those questions for you in open session at this time.
Mrs. Hughes.
I have a couple of questions. One is probably best for Mr. Mira, one for Ms. Linetti. We saw the numbers of the VBEA members. How many full-time teachers do we have?
There's about 5,500.
What about part-time? I'm just curious how these numbers correlate. There
Well-
were 4 categories.
Total, all employees are full and part-time employees, about 15,000. That floats back and
Okay.
forth. I don't have those numbers memorized like part-time teachers because we have part-time other positions, but
That's fine, but those
Yeah.
4 numbers, I mean, that covers everybody,
Right,
those 4 categories. Okay, thank you.
okay.
And then my question for Ms. Linetti was, clearly the VBEA is in favor of this. We have some board members who are VBEA members. Is it appropriate for them to recuse themselves?
I don't believe a decision on what you do about collective bargaining and whether you either make a decision to accept it or study it or to just not accept a collective bargaining is something that someone who is a member of the VBA would need to disqualify themselves from. Potentially, if you got into a situation where you were certifying a group in which the VBA was seeking certification as a bargaining unit or an exclusive bargaining agent, we'd have to look at that a little bit more closely as to whether you had a direct conflict or not. But I
So
think-
if I had a potential conflict, I would not participate in the closed session or vote. But in this case, there's potentially a conflict, but we don't decide whether or not they have a conflict until
You're
it gets
not-
certified.
I think I would specify, there is not, no group has come forward at this time, and they can't come forward until May 1st. What we're asking you is direction as to where you would like to go on collective bargaining. That is a general concept that would affect all groups in the same manner. I do not believe that would be a conflict. If you decide to accept some form of collective bargaining in which the Virginia Beach Education Association then put in some type of petition, we'd have to look at that a little bit more closely as to whether you had a conflict, but you're not there yet. What we're going into is asking for direction tonight, so I don't think you would have to disqualify yourself tonight from that.
Okay.
Anyone else at this point in time?
Ms. Manning has her hand raised.
Go ahead, Mrs. Manning.
Thank you. Ms. Linetti, when you're discussing what can be discussed in closed session and not, it would seem to me that if you're discussing which way you're leaning toward a resolution to allow collective bargaining, to not allow collective bargaining, to defer, it seems to me like those types of conversations need to happen in the public, so the public can hear and participate in that. I understand that any legal discussions and advice should be in closed session, but it seems like you're asking for the board to give direction on kind of where we're leaning, and it seems like that should be done in open session.
If you would something, that would come at another meeting. If you're asking us to bring you the different options, to draft something for you to look at, we need to know where it is you want us to go so that we can draft that for you. So there would not be a vote tonight on any action. You're going to tell us, we hope, in closed session, what you would like us to do so that we can go through it and draft something for you that you can look at.
I don't understand. I don't understand why that should be enclosed.
Because if you want legal advice from me as to the consequences, what could happen from this, what legal ramifications are, I would answer those in closed session. We would bring something back to you that you as a board would consider doing, depending on what you want us to do. We just have not had direction at this time as to what you want us to do. And my concern is that you will, between now and the next school board meeting, that you might receive some requests coming in and that you be prepared to do that. So tonight, the information we're presenting to you now is for those of you who have not participated in the collective bargaining trainings that have been available for you at the statewide level. And then if you want us direction, how you want us to go and start drafting, there are some other legal questions I would ask. That needs to be done in closed session. We would not be asking you to vote tonight. We would just take whatever you give us and start working on something so we can bring it back to you at another school board meeting.
So I agree that regarding legal consequences should be asked in closed session. However, I don't agree that preferences and providing direction to you or administration should be done in closed session. I feel very strongly that these are conversations we need to be having publicly.
That is an option. You do not have to go to closed session for this. We put it on there for the option for you to do that, but you can certainly have those conversations in open session also.
So if we can have them in open session, then we shouldn't be having them in closed, in my opinion, based upon the Freedom of Information Act laws.
You vote as to what you want to go into closed session for. We gave you the option to go into closed session so I can provide you some legal advice if you want it, but you do not have to go into closed session for this. You can certainly do this in open session if you choose to do that.
We're still subject to the open meeting laws and can only go into closed session for certain reasons based upon exceptions provided under FOIA and the open meetings laws. So that's I feel very strongly that it would be a violation of the Open Meetings Act to go into closed session to provide direction on what direction we're heading on this. So that's just how I feel on that.
that's a decision the board would make for themselves. So you could decide whether you want to go closed session or not.
I'm just going to point out quickly that the recommendation here is to enter into closed to discuss legal matters with counsel related to collective bargaining and whether or not outside counsel or other expertise should be retained. I think we need that information. That's an in-closed session discussion. Other deliberations about where the board wants to go with resolutions can happen in any time. You can choose not to take action, and we can wait till we get a request for certification, and then you guys have 4 months to take some action during that time. Or you can have other deliberations, but we need some conversation about what's on the screen as a recommendation in closed session. I need to know with Ms. Linetti where we're going around, particularly outside legal counsel, where the board leans on that, and what other legal questions you may have about the legal ramifications of entering into collective bargaining agreements so that you can make a better informed decision in a deliberative process outside of that. So that was why the recommendation's worded the specific way that it's worded. So I just want to make sure, at least from the administrative side, I'm clear with you all about that.
Thank you, Mrs. Weems.
Yeah, I mean, obviously, when we get legal advice, that's closed, but like I have questions and I don't know what this goes under. I mean, it's hard for me to advise what road to go down on when I've got like, what is it gonna look like? How much time is this gonna take if we go into collective bargaining? How much time, how much extra staff time? I mean, just
You can ask those
logistic
questions now.
questions. Okay.
There's nothing there.
Okay, so with collective bargaining, how much extra work is that gonna put on our employees? How much extra work is that gonna put on our staff? How much, I mean, I just need to get a picture of
Yeah.
what this looks like.
So here's one of the dilemmas that we have that I think we're trying to convey here. We're not experts in collective bargaining. This is not something that we've done in Virginia.
Right.
So you don't have a superintendent who's engaged in collective bargaining. Our attorneys have not engaged in collective bargaining in a formal way because that's not something that we've done in Virginia. We have some background in meet and confer, as you probably remember. And so we certainly can talk a little bit about meet and confer and the time that that takes. But what I can tell you in terms of what, that specific to your question is I don't have an answer for you. And that's one of the challenges that we have is we don't have a lot of answers to questions about what collective bargaining. I mean, you saw the list of considerations that you're going to have to think through if you were to adopt a resolution which would allow for collective bargaining, right? So how do you determine that a group is properly certified? How do you define or limit the bargaining groups? How do you stagger or should you stagger the acceptance of those groups? What's the program and process for that? Who can be involved? What issues can be included or excluded from the process? How do you resolve disputes? How does all of that align with state law that already exists for those processes and board policies that already exist for those policies? So there's a lot to uncover here. And, we've done kind of a preliminary discussion with some folks who have engaged in these processes. You, I think saw a cost estimate. Somebody asked about it. There was a cost estimate of over $1 million for Virginia Beach to engage in collective bargaining because of the additional staffing that we will need on the administrative side to engage in that process, right? So if you talk to folks who do engage in collective bargaining, they have multiple full-time staff members. This is at the municipal level, at the county level, and at the school level. In states where they engage in this, multiple full-time staff members who are responsible for the negotiation processes and for the adherence to those contracts, and then for the dispute resolution processes that come as a part of those contracts. And so that's a lot of work. Because if you certify, for example, if you were to certify that an organization represents teachers, now all teachers are covered under that. Depending on how you legally define all of this, then teachers may all be covered by that. And then we would have to resolve every dispute per the contract if the board allowed dispute resolution to be part of the collective bargaining process. We would then have to figure out how that aligns with state law and where state law might override, a state or federal law might override the contract language, or vice versa, or board policy. So it's very complicated. And one of the reasons that I asked the specific question on that recommendation is I do believe we need to get some people with some expertise to work with you all. And one of the reasons we presented you multiple considerations, not recommendations, but things you need to consider right now, because I don't have a recommendation for you, is because we want you to know that you have options to think about giving yourself time to learn more about this process and bring in expertise to help guide you in this discussion. Is that
Let me
helpful?
say-
Yes, yeah, and I would just, I would like to say though, if we do get expertise, I do think the conversation like can be at a workshop, obviously where we would have questions and stuff like that, because
Here's
the
what
public
our
needs to hear
thinking
this
was,
too.
if I can put it. If you were to tell us, we absolutely do not want collective bargaining, that is one simple resolution. I don't have to have these other discussions about outside groups, we just write that resolution. If it's defer, and there are school divisions have done this, Hampton has done this, they're going to defer for a year and spend a year talking about it, that's also a relatively simple resolution. It does not require all the facts and figures and calculations that we would have to do if you chose a different model. Those are relatively easy to do. If you say we really are interested in developing something in the next couple months, that's a different conversation, in which case some of that I would discuss with you in closed session, what our thinking is there. We're trying to get some direction from you because before we incur expenses or hire people and incur expenses for us, if you let us know which direction you want to go in, we can help you with that piece of it. There are one decision is relatively easy. Deferring for a certain time period is also not that difficult for us to do. We would set the time period. Again, Hampton City Public Schools recently did this. They are going to spend the next year exploring this. They have put some money into exploring it and will come back to their board. Other decisions, if you're going to implement or do things, will require more expertise and time, in which case we would talk about hiring counsel and other issues of that. That's what I would go into closed session for. That's why we're bringing it to you tonight. Before you incur expenses, if you let us know which way you want to go, it might help us be able to give you better information.
But to be clear, if I may, if there were enough of us who felt we just need more information, that more information would come from an outside counsel at this point?
It could, depending what you ask us to bring back to you. As we're trying to point out to you, there are multiple options. We can look at all those, but you would need to tell us where you want us to go. That would help us provide you some guidance as to cost, staff, time periods on it. If you say absolutely we do not consider this, that's one simple resolution. Again, deferring it for a certain time period is a simple resolution that we can be back to you. Anything else, we probably need to go into closed session to talk about hiring and some other issues that might be involved in that. Again, I know many of you have done the trainings on it. We were trying to point out to you tonight how complicated some of these decisions are. I know one example right now in Virginia, that's Alexandria has adopted the city of Alexandria, not the school division. Everybody else is looking at that. There are no models that we can go out and adopt right now. So you would have to do all this work and we'd have to make this decision. Again, we're not saying we won't do that for you. We just need to know where you want us to go before we spend a lot of time and effort, because you can see your school division's very busy with other things right now, getting it up. We need to know how much you want and when you want it and how you want it so we can help you.
Mrs. Franklin?
Colleagues, I just wanted to mention, I did actually attend the training in November. And one of the things that really stuck in my mind was one of the attorneys that was presenting the training said that, you have to be very, very careful when it comes to, determining how you're going to put together these collective bargaining options, because once you give away any of your authority as a board, you will never get it back. And I just feel like this is a very monumental time and decision, because this is going to impact every single future budget, every single future board member. And so I do not feel like we should, we should look at it for what it is. I mean, this is a huge decision, in my personal opinion, and they even said that in the training. So I would just caution us to be very thoughtful about how this will impact every single future board, superintendent, budget, and I personally want to know, can't, Ms. Linetti, do you actually feel equipped to, before we spend money on this, do you feel equipped to provide some legal counsel to us yourself? Or do you,
What I would say to you is if you were going to go a more formal collective bargaining, in which case I would then at that point recommend groups that are specialized in this area. If what you're doing is one of the, an alternative form of something you've done before, like a meet and confer, an employee input process, you have procedures for that already. We might also be looking at a group to do that, but maybe not. Again, if you're just saying, no, we do not want collective bargaining, that's a simple resolution. Deferring is a simple resolution, and then you tell me, and you tell the superintendent, what are you looking for us to bring back to you? And we will tell you the appropriate groups to bring back to you and when it would be appropriate to bring an outside group.
okay, thank you.
Okay, Mrs. Melnick, then Mrs. Anderson.
I think it's important maybe to state what the law says and then maybe let us know what city council is doing at this point.
I believe city council is going through much the same conversations that we are right now.
What does the law say?
What the law says, and it's actually pretty simple right now, is that as of May 1st, you can either adopt a resolution, well, you do nothing, or you can adopt a resolution stating what your intentions are towards collective bargaining, or if you don't do that, groups, and it could be also any group seeking to be certified as a bargaining unit for public employees can then submit something to you. In most cases, in more established programs, there is a format that you would have it, that you would expect it to come in, what you would be looking for. Most cases, you would find out what the groups are. So if I came in and said, I want to represent bus drivers, you would know what the school board was expecting bus drivers, how many bus drivers, how many people you're going to do it. You can also limit. If you want to say, in most cases, when you do collective bargaining, you do not have your human resources department participate in that. You generally don't have managers participate in that. You would disqualify some of those groups. If you don't make those decisions ahead of time, when the first group comes in, any group after that, you have to start making those decisions very quickly and define it. You may not be able to control it, which is why you may want to get ahead of this and make the decisions as to what groups. There's also currently no rules in Virginia as to what you can collectively bargain for. We would need to go through with you what the laws are, what your authority is, what things are currently able to be negotiated, what you would not be able to negotiate. You can also make your own decisions. You've not had any of those conversations at this time. I can show you what other localities have done, what other states have done. You would want to consider. You would also want to reserve certain rights to yourself, that you would not give away those rights. Those decisions have to be made. You might also say, we only want to accept petitions a certain time of year so that you're done before your budgeting process happens. So you might only accept certain times a year. Otherwise, you'd be considering petitions all year long. The size of the groups, the nature of the groups, when you'll accept it. All those are decisions that you need to make. And again, the law is not clear on it. The law right now is dealing with time periods. It talks about the certification, decertification process. It does not give you other details on what a bargaining unit is, what the rules are going to be, what procedures you have to follow. So again, we would be creating this area of the law. Everybody else in Virginia is pretty much in the same boat. Right now, you have the ability to make all these determinations.
All right for now, Mrs. Mel. Okay, Mrs. Anderson, then Mrs. Manning.
It's my understanding that your plan is to go into close for further clarification and information from our council, but that no voting will take place tonight. Is that correct?
Correct. If you direct us to bring your resolution, again, if you take no action, obviously there's nothing to go. But if you're directing us to bring resolutions or further trainings, other information, we have to bring that back to you at another school board meeting.
Okay. All right, so just to clarify, so somebody could ask you to develop a resolution and bring it back with things that they've asked you to do, and then would people vote on that, or would we then just wait for you to develop a resolution and then we have a discussion and vote?
One option. You could also form a group for us to look at and bring it back to you. You can schedule time periods for us to bring certain decisions for you back and what you want us to bring back to you. We can do that.
So with this information that we have, hopefully, I know that I actually attended a meet and confer session, and then I did another one with VSBA in November. So I've actually done two, actually I've done three, but I mean, I feel like I'm pretty up on, you know, what it's all about, but I'm always willing to listen and learn more about it. So I hopefully those people who have not attended the information sessions before will be able to hear about this tonight. And if not, then I'm sure they could always access the VSBA training that they've done as well. Thank you.
Okay, Mrs. Manning and then Ms. Owens.
Thank you. I've done a lot of research on this. I watched one of the VSBA trainings. I've also spoken to a couple of experts in the field. I've spoken to Ms. Linetti about this as well. Again, I think that any direction that we are providing to staff needs to be done in open session, not closed session. So I'm going to throw out my viewpoints right now because I don't think it should be done in closed. I would like to ask that we just adopt a resolution to not allow collective bargaining and not open this can of worms. If we even explore this, it could cost us a lot of money. It could cost us a lot of staff time that we don't have. Our focus right now needs to be getting our kids back to school full time this fall in person. And so I'm going to throw out there right now that I think that we should develop a resolution to not allow collective bargaining.
We're okay, Mrs. Manning. We have Ms. Owens and Mrs. Weems in the queue.
Okay, thank you. I guess I have a request from I don't know if it would be to Mrs. Linetti or admin, but I would like to get more information from a historical perspective from Virginia Beach Schools about previous meet and confer processes that we had in place and why they are no longer in place, if that's the case, so that we have the information fully before going in and not repeat past things that have already been tried and failed or whatever. And so if that's available for some pieces of it tonight, or if that's something that we would need to get more information from, it's something that I would want to consider before.
I'll share a high level because I actually ran it years and years ago. So ultimately, the school division had meet and confer. I don't know when it started. It was for years and years. Meet and confer represented whatever association groups we had. They would meet prior to the budget season. Association, I'll keep it broad. Association, based on their number of membership, would get X amount of people at the table. So there were 5 people from the membership and then 5 administrative team. And ultimately what they did, example, I'll give you an example. If one association had 60% of their employees, they would have 3 seats at the table. And then I would have to find 2 non-association members so we represent all employees have an opportunity. Actually in that group. Proposals would come from the association to the administration. Proposals would come from the non-association to the administration. And the administration would make proposals. And ultimately, what we did, we set a table through meetings, we discussed back and forth, data, we tabled things, we tentatively agreed to things, and then in the end, at the end of the sessions, if we couldn't agree to table them or tentatively agree, I would come to the board and present. I wouldn't present the things that were tabled. I would present the things that were tentatively agreed on, and these are the open items. It was after I left and became a principal, it was eliminated because there was, and Cammie wasn't here. There was a legal opinion. I'm sorry. You're the lawyer in the room, or one of the lawyers in the room. Anyway, there was a legal opinion that it was collective bargaining and would stop. The school division then developed the employee input process through evolutions of what we have today, where every single employee has an opportunity to submit information to us. It's twice a year. We collect that data, and we look for trends, we look for issues, and like I said, I'm going very quickly here. Then that data is used to make a lot of the changes that you've all seen over the years. And that's probably, it's very quick. Do you have any other questions or?
Yeah, so let me just layer to this. So it wasn't that meet and confer, failed, as you sort of asked about. There was a finding that it was collective bargaining, and meet and confer is considered a form of collective bargaining. Well, collective bargaining prior to this most recent legislation was not allowed in Virginia. And so because of that legal finding that it was in fact collective bargaining, it was ended as a process, so we developed other processes.
There's a decision issued by the city attorney's office in January of 1999 as to your MOUs, memorandums of understanding you entered into, which was basically the meet and confer process. If you follow the history, and again, it's in, I think we forwarded to you the task for the VSBA task force finding, it goes to the explanation of the law. There was a case in 1977 in which the courts determined that what Arlington was doing was collective bargaining, and that local governments in Virginia had not been granted the right to go into collective bargaining. That was accurate at the time. When it was brought to attention in my office, I was in the office, but I wasn't here full-time yet at the schools at this point. The city attorney's opinion was entering into binding agreements, memorandums of understanding, was collective bargaining, and that Virginia had not authorized school boards to do so. That's why you switch back into it. And again, that's exactly what the law is changing. It is not mandating that you do it now, it's allowing you to do that. And again, I'll just go back to some of the considerations you have. Because you do not have taxing authority as a school board, the law also says any agreement you would enter into, if you were to do collective bargaining, cannot prevent you from your necessary budgeting and finance decisions on there. I know the Attorney General's office has opined recently that you cannot change the grievance procedure for employees. That's one of the other areas. There are other things in law that are set for you. You also have policies on leave issues, on other procedures on that. That may or may not be something you can change, but some of these things that you traditionally could do in collective bargaining, you may not be able to do in Virginia because of your political structure. Those would be things you would have to consider. You may want to, and I'm sure we would recommend that you look at what your policies have for leave procedures, what your policies have for hiring and promotion on there, so that you understand what's already in place and whether you want to be able to negotiate those type of issues. I know Mr. Merrick can talk to you about some of the things, but I think he's mentioned the type of things that you had looked at before.
Okay. I think that's helpful for me in the sense that it sounds like our district at some level, whether it was a much lower level, has participated in some collective bargaining procedures, whether we were supposed to or not at the time. So I do think at some level it is doable. I think it's messy, and that's part of why we're here and what we have to do, and having more voices at the table is messy. That I don't think that means we shouldn't do it, but I do think, as Ms. Franklin said, it doesn't need to be rushed. It needs to be right. And so, while obviously I don't have a full opinion at this point and we're still gathering information, right now I would be leaning towards deferring and picking a time frame and with the understanding that during that time frame, we would be getting additional information about some initial starting points for moving forward, because it sounds like, even though it's messy and even though it's going to be hard, it's something that has happened before, and that ultimately, now that this is the law of the land, there are going to be teachers and districts who allow some collective bargaining. And if those districts are now going to become more enticing for our employees, where they're going to feel that they have ability to have more say in their work environment, or whatever they're allowing in their collective bargaining, we need to be proactive in making sure that our employees know that we're hearing them and that we are including them at the table with a voice, however we decide to do that. And so I think it's going to be important for us to figure out how we're going to lay that out for them. And we can call it whatever we end up calling it. But I would be opposed to just saying, take it off the table, we're not going to do it because it's messy or because it's a can of worms or whatever else. That's what we're elected to do, is handle cans of worms and all of those things. So that's where I'm at right now.
Madam Chair, for clarification,
Microphone.
Manning and Anderson still have their hands raised. I just need to know if I should put them back in the queue or if that's old.
Mrs. Manning and Mrs. Anderson raised
I see
hands,
Manning
yes or
raised
no?
her- She lowered it.
Okay.
How about Mrs. Anderson? Okay, I'm gonna take her out. Right. Oh, are you back in the queue? Okay, I put you back in the queue.
We have Mrs. Riggs and Mrs. Weems.
Well, that's fine, I'll put you.
Mrs. Riggs, please proceed. Okay, Mrs. Anderson after Mrs. Weems.
Okay, I'm going to go along with what Jessica said. I'm not going to, continue saying it over and over again, but I agree with what Jessica says. I think we should give our employees the opportunity to be able to have a voice at this table, and it's not going to be easy. I mean, as she said, when you have more people involved, but I don't think we should just shut it down. As far as not having that opportunity for our employees to speak and speak for themselves, and the state has allowed us to do this and to talk about this. I think I don't want to rush it. I don't think we need to jump right into it. Let's just do it. Obviously, it's going to take some time and preparation and a resolution to do it. But I am not in agreement to just say no. I think we need to look into it, get more information, take some time to decide how we're going to do this, and try to do it as best and as right as we can. But I do not want to pull this opportunity out from under our employees and say, no, you don't have an opportunity to say how you feel about this and have a voice at the table.
Mrs. Weems, then Mrs. Anderson.
Yeah, my direction would be option B, to pass a resolution. My first preference would be to not allow collective bargaining. My second preference would be to defer.
Mrs. Anderson?
I agree with Mrs. Riggs and Mrs. Owens. Pulling the rug out from under our teachers and not giving them a voice could possibly lead to teachers leaving our division and going to divisions where they do have a voice. And I can tell you, as a retired teacher of many years where we did not have meet and confer, and then we started having meet and confer, there were a lot of things that we were able to sit down at the table and discuss and bring our opinions to. And I can tell you, one of the things that stands out in my mind and has always stood out in my mind was the right to have duty-free lunch. And when I tell that to people, they look at me and they go, "What?" And I say, yeah, we had to sit down at the table and we had to meet and confer and beg for the administration to give teachers in our city a 30-minute duty-free lunch. And that is one of the biggest things that stands out. It's not the only thing that we had to bargain for, but it's little things like that that give teachers the voice and the understanding that administration, hey, listen to us. You know, we have a right to give our opinions on things too. So that's what Meet and Confer is all about. And whether we call it collective bargaining or whether we call it Meet and Confer, the fact that that was taken away from teachers because of attorney general who decided that it was against the law in Virginia, and so now we had to pass a law allowing it. So I'm not in favor of disallowing it. I do think maybe we ought to take our time and defer a decision until a few months from now. And so if we can come up with a resolution that just basically says we are considering it and that we will make a decision, down the road, maybe in a couple of 2 or 3 months. But we need to study this. We need to figure out what we need to do and come up with a resolution that's all encompassing. But I am not in favor of just saying, no, we're not going to give our teachers a voice. We're not, that's not what it's all about. And so this is an idea, this is a way of giving our employees, not just our teachers, but our employees a voice. And I'm very much in favor of doing that. And it has nothing to do with the fact that I have a lifetime membership. It has to do with the fact that I think we ought to do what's right for our employees, period. Thank you.
Okay, Mrs. Melnick, then Mrs. Hughes.
And I will very quickly say that the law allows this, and it would be terrible to slam this door in our employees' faces without a conversation. They deserve the opportunity to have us talk about this, first of all. And we speak so loudly about transparency and public participation, and that's exactly how I view this with our employees. And so I'm asking for transparency with this, and I believe we owe this to our employees. Now, that being said, Dr. Spence, how could you speak on behalf of your staff at this point, knowing what you know since the law passed and what we've experienced in the past and perhaps moving forward?
Well, I think, I mean, if I were going to be pinned down on a recommendation that administration would make, if that's what you're asking, I would say we would ask for a deferral on a decision so that we have time to learn with you about what the best possible conclusion might be, whether that's to not allow it or to allow it with whatever those parameters are, but kind of understanding what that is so we have time to collectively build our expertise. I think that would be I mean, I didn't want to come with a specific recommendation, but if you were going to ask me what administration wants, because I know you all have to think about this, right? But if you were going to ask me what we would like, I think a deferral would make sense so we could have that conversation together.
I mean, Ms. Mel, if I could point out, Prince William County Public Schools does something along the lines of Meet and Confer. Their attorneys have presented on this. My understanding is they have a staff of approximately 10 people, including outside counsel that they hire to negotiate. As much as you might say it's something you could do in-house, what I have seen from people is you do end up having house staff pretty much devoted to doing this. And in most cases, depending on the level of what you're agreeing to and how complicated it is, you do end up hiring arbitration firms or law firms bringing in. So there is expense and a time. It would not.
Well, I understand what you're saying, but I'm talking about educating ourselves first. And I think that's what our employees deserve, is for us to educate ourselves so that we know more and we can make an educated decision about this moving forward. I mean, our employees deserve that.
I think one's not a contradiction of the other. I think, and my question still remains in whether this is what we discussed in closed. Are we at the point after this discussion we're having now, would the next level of educating ourselves involve an outside counsel?
That I'd like to talk to you in closed session about, but going with Dr. Spence's recommendation, I think you need more time to consider it. We just, at a high level, showed you the types of decisions that you need to make. Those are a lot of decisions, and you would need to take time, and I would see this coming to you over a series of meetings or time period that you would make decisions, because some of the decisions that you make lead to what the process will be and how the staffing and the budgeting that you need to do. You have to make some of those decisions early on. So I don't see this, it's not a one meeting thing. It would be coming to you multiple times saying the first round we're doing is, here's what we think you would look like. Second round would be coming back based on what you said, here's another process, and building out is what you think the time period and what you think the budget would be. So I see that as multiple opportunities bringing back information to you to look at. It's very complicated. If you've read any of this, you'll see how long those definitions are. Every one of those definitions you have to look at and consider. Then you got to consider the processes. You really need to take time to educate yourself on what is already in your policies, what the law guarantees. And then Mrs. Anderson was suggesting the duty-free lunch. You need to know that that's in state law. You need to know what your leave policies are so you understand what you're willing to give away. As Mrs. Franklin was saying, if you give away things, you're not necessarily going to get them back. So you want to decide ahead of time what you want to do. That is not a one meeting thing. That is multiple meetings. So we would want to know the time period you want to do that on, and then complicate it after that. Then I will discuss with you in closed session my recommendation.
And with everything else we do, education is the key. So it's Hughes and then Holtz.
Mrs. Hughes.
Well, I think saying that this is the law now is not just the best reason to support it. I'm sure we all have varying opinions about what these are, but probably every one of us can think of a law at one time or another that just because it was legal, it wasn't the right thing to do. As far as giving voices, I found it interesting when I saw those numbers that the VBEA only represents 8.5% of our employees, yet they seem to have a huge voice. It's the other 91.5% that call us or send anonymous letters and try to catch us out in public because they don't seem to have a voice. And it's that small, really small, considerably smaller than I thought it was group that I'm sure will be pushing for this. One question that I would have is, if we say yes to collective bargaining, could the teachers or could the employees shut our schools down?
Right now, you have the law does not allow for strikes or work shutdowns. That has not changed in the law. And in fact, if you're not familiar with this area of the law, if two or more people get together and attempt to prevent you from doing work or do strikes, we actually have to fire them for a 12-month period. There's a way they can appeal to court to get it overturned. That part of the law has not changed, so they don't have that ability. You can also, if you decide to do something like this, you can define what they can and can't do. But right now, the anti-strike pieces still remain in there. They can't shut down anywhere. That is part of the law in Virginia at the moment. You could also make some determinations. You could limit the scope of what they can do, what they can bargain with you, and what you will be willing to do, and what you will reserve for yourself. So that would also be decisions you would want to make.
All right, thank you.
Okay, Mrs. Holtz, and then back to Mrs. Franklin.
You hear me here?
Yes, ma'am.
This would be a huge disservice to our employees if we do not accept this bargaining. This has been a long time in coming. We've been in the dark ages for so long. We talk about a global society. Let's talk about our society, our global society within Virginia Beach City Public Schools. And it's not just teachers. It's all employees. You're right. It will affect every one of us, and it might be difficult to get started. But I think we should resolve to accept it for what it is and move forward and educate ourselves and be more informed. And then, of course, we'd have a starting point to say, oh, let's put it off, let's defer it until we get more information. Don't be chicken. Stand up and have the courage and the guts to fight for teachers. The more people involved, the better we are. We shouldn't be making decisions for them only on our own. And Jessica made a really good point. We're already losing teachers. We don't need to lose any because of this. This is an insult to not accept this from teachers. And Mrs. Anderson said something about making gains. Well, I was a teacher when we had the meet and confer. We never had any free planning time either. And when I tell younger teachers that, they look at me incredulously and say, "You didn't?" I mean, we weren't being treated as humans. But it was the meet and confer that allowed this to happen. We need to do this. We need to get out of the dark ages. And if we don't, every other school district in Virginia will be laughing at us. We need to do this, and we need to do it tonight. Thank you.
I think we've reached a conclusion with this level. Ms.
I'm sorry,
Franklin.
if I could just say one other thing. It does concern me a little bit, colleagues, just because I feel like it's one of those situations that you either support this or you hate teachers, or you encourage it and you love teachers. I don't believe that it is as simple as that at all, because just like I have tried very hard to come into the school board open-minded and listen to all viewpoints, I really do believe that we have to also look at the other side as well. We are not just here to help promote teachers, which is what we certainly all want to do, right? We do. But we're also here to be fiduciary agents for our budget and our taxpayers. And we also are here to make sure that the administration is supported as well, and they've got the encouragement and the resources and the support by this board to do their job well. I think it is a little bit, it's a little bit of a slap in their face to say that we haven't been open-minded and that we haven't done what we could to support teachers. We just passed a very large budget for the teachers and the staff. And I think that that was the right thing to do. And I think by saying that we have to do this, or we don't support teachers, or we don't support bus drivers, that is such a sweeping negative image for what we're already doing at BBCPS and what we're doing as a board, quite frankly. I mean, I know that I'm new, but I have to tell you that I think that we have done a very good job up to this point to support the teachers and to support the staff and the superintendent and his administration. Maybe I'm wrong in that, but just in my short period of time that I've been here, I don't feel like we've done a bad job doing that. And I don't want this to be an emotional decision, guys. I want this, or ladies, everybody. Sorry, I'm from the north, so that's what we just say. But I want this to be a decision that is based on us trying to do the best thing for the community as a whole, for VBCPS as a whole, and not just a decision because here's my concern is that if I say that I have some reservations, then I'm going to be viewed as somebody who does not support teachers. And that's not the case at all. And I know I've only been here a short time, but I can tell you, I've spent 20 years supporting teachers. I've spent, 4 months, trying to do what I could for teachers as well. But that does not mean that I feel absolutely 100% about this either, And so, I want us to please not make a sweeping decision that if you are for or against this, you're either for or against teachers or for or against, the staff. I'm going to ask us right now to create a situation here where we do not bring emotions into this. Past experience is great, but it should not completely overwhelmingly make your decision for this. Because we have to represent the community as a whole, I believe. So I'm just going to ask that we use discretion and not use emotion during this decision. Thank you.
Okay, before we ask Mrs. Melnick to make the motion to go into closed, I need to clarify with Mrs. Anderson. Are you in the queue for a final comment or question?
Do you want to put the Jericho Road in?
Yeah, I'm not, I'm sorry.
Okay. And just For you and Mrs. Manning, I need to ask Mrs. Linetti, because we need to get Mrs. Manning and Mrs. Anderson back on Zoom for our vote after the closed. So how can we manage that?
I think we could, if they want us to call them, if they want to give the clerk a number, we could call them when we're done to do the remaining action items.
Did you hear that, Mrs. Manning and Mrs.
The
Anderson?
other choices, and this, you might not like it, but you could amend the agenda right now to take the further action items.
We're actually not going to end the Zoom meeting. We're simply going to mute and turn off the video during close. So after close is done and we come back, we'll be able to unmute and turn the video back on, and they'll be able to rejoin. They'll never leave.
But we want to give, I mean, but they won't know what time that was going to, we can't give them a time yet.
You're correct. You'll have to stand by and wait until we reopen the Zoom.
So, okay, we will, Mrs. Manning and Mrs. Anderson, we'll call you both when the closed session is finished.
Or just text, but we can text you.
Mhm.
That's fine.
And Mrs. Manning, did you hear that?
Yes, I do need to, I have a family obligation at 9 p.m. So I will try to be available.
Okay, I understood. We'll text you irregardless. Just if it works out, fine. If not, okay.
Thank you. Thank you.
So Mrs.
Am I adding,
Melnick, would
are
you?
you adding anything to the closed session?
No, Ms. Stu says we can bring that up at another meeting.
Okay. All right then. With that, I make the following motion: that the school board recess into a closed meeting pursuant to the exemptions from open meetings allowed by section 2.2-3711, part A, paragraphs 1, 7, and 8 of the Code of Virginia 1950 as amended for the following reasons. 1. Consultation with legal counsel. Consultation with legal counsel and briefings by staff members or consultants pertaining to actual or probable litigation where such consultation or briefing in open meeting would adversely affect the negotiating or litigating posture of the public body, namely to discuss A, status of certain pending complaints and or litigation against the school board, B, discussion regarding collective bargaining laws and procedures and hiring of outside counsel. 2, consultation with legal counsel. Consultation with legal counsel employed or retained by a public body regarding specific legal matters requiring the provision of legal advice by such counsel. Consultation with legal counsel concerning current legal matters.
And a second. Mrs. Riggs. Okay, all in favor, raised hand.
We have 9 votes in the affirmative to go into closed session.
Okay, thank you. A short pause here. Chair, the school board committee is reconvening for a final vote on remaining action items. The first is.
Mrs. Rye, we do need to do the certification of closed session.
Oh,
Whereas the school board of the city of Virginia Beach has convened a closed meeting on this date pursuant to an affirmative recorded vote and in accordance with the provisions of the Virginia Freedom of Information Act. And whereas section 2.2-3712D of the Code of Virginia requires a certification by this school board that such closed meeting was conducted in conformity with Virginia law. Now therefore be it resolved that the school board of the city of Virginia Beach hereby certifies that to the best of each member's knowledge, only public business matters lawfully exempted from open meeting requirements by Virginia law were discussed in the closed meeting to which this certification applies, and only such public business matters as were identified in the motion by which the closed meeting was convened were heard, discussed, or considered.
Second.
Actually,
Mrs.
it needs a first. I didn't motion that.
Okay, first, a motion, Mrs. Franklin. Second, Mrs. Riggs. Okay, all, raised hand if you're in favor.
Chairman Moran, we have 9 ayes with 2 abstentions with Ms. Anderson and Ms. Manning since they were during the meeting via Zoom.
Thank you. Now that brings us to agenda item 19, vote on remaining action items. The first is superintendent evaluation instrument for fiscal year 21 amendments. Again, to reiterate, this was the evaluation instrument. It was a product of the governance committee, and it concerned the compression and consolidation of some of the indices under the standards, which were not changed. With that, is a motion to approve? Mrs. Riggs, a second. Mrs. Felton, all in favor?
We have 10 ayes with Ms. Manning not voting.
Okay, the motion has passed. Second, so 19B, I guess, is the superintendent summative performance evaluation process, which was discussed earlier in this formal meeting. The same process essentially that was used as last year, with the updated, the eliminating the particular year so that it can be a product to use moving forward until such need to revise. So with that, motion to approve? Mrs. Franklin, a second. Mrs. Riggs, all in favor?
We have 10 ayes and 1 abstention in Ms. Manning. No. Oh. I take that back. We have 9 ayes.
All opposed?
And we have 1 opposition in Mrs. Hughes and a non-vote for Ms. Manning. So it does pass with 9 ayes.
All right. And with that, this formal meeting is adjourned. Good evening, everybody.